Welcome to the Heritage Planning Group Educational Workshop Series. To lay a strong foundation, we bring you our first installment, Understanding Estate Planning and Living Trusts. My name is Chuck Stevens, founder and CEO of the Heritage Planning Group. We are a consulting firm helping clients help themselves in putting together their own estate plans, which includes simple trusts, power of attorneys, and wills. What separates us is our innovative business model, Do It Together. I'm sure you've heard of Do It Yourself. The Home Depot has built a multi-billion-dollar company based on this principle. So we wanted to bring that same philosophy, but better. We believe that no one has more vested interest in your financial success than you do. So we put together a team of experts, documents, and resources to look over your shoulder while you remain in control of your financial legacy. Thank you for taking time out of your busy schedule, and please enjoy our presentation. First, let's define what is part of your estate. This is a snapshot of everything you own at any given point. Your home, as well as any other real estate, bank accounts, business assets, investments, retirement benefits, annuities, life insurance policies, jewelry, cars, RVs, and collectibles, even your furniture and other personal belongings. When you start adding it up, especially when you add in the death benefits from your annuities and life insurance policies, you may find you own more than you thought. Simply put, you have to evaluate all of your assets as if you were the IRS and you needed to put a value on your entire net worth. Why do estate planning at all? There are 5 most common reasons people choose to proactively plan their estate. First, control of their assets. The who, the what, and most importantly, the when. Secondly, control the beneficiaries, protecting your children and grandchildren from ex-spouses and creditors. Third, more money to the heirs by decreasing fees, costs, and taxes. Fourth, time. Proactive planning reduces the time needed to go through the process of closing an estate. But the biggest reason of all, peace of mind. That's all been taken care of, so the children don't have to worry about all the nonsense of distribution, and they get through the grieving process that much quicker. A proactive estate plan will also protect you and your family if you're ever incapacitated. It will let you, not the court system, keep control of your assets and carry out decisions about your medical care when you cannot. So who needs estate planning? To a degree, just about everyone. The older you get, the more you start thinking about giving your assets to your grown children, grandchildren, charities, and other loved ones. Couples with children especially need to proactively plan their estate. Blended families are particularly strong candidates for thorough estate planning. Even single adults, no matter the age, should consider simply organizing their thoughts and wishes into an estate plan document. Estate planning isn't for the wealthy. It's for anyone who wants to organize a proactive plan for what life throws their way. Here are a few examples of either poor planning or no planning at all. When Elvis Presley passed, his fortune amassed to over $10 million, but with the help of poor planning, his heirs were left with less than $1 million. And Groucho Marx, he didn't have any plan documents. His family got him declared incompetent and had the courts declare him unfit to manage his own affairs. The family lost control over his assets, and the amount of cost nearly took everything. And most recently, I'm sure you heard that Prince died without an estate plan in place, so now it will be years and millions in fees and costs until his estate is settled. If there's anything good to come out of this, many people are now choosing that they don't want this to happen to their family, so they're doing something about it. I'm confident that when you hear stories of people that had to close the estates of their parents, the ones that said it was a nightmare are the ones who had little to no proactive planning completed by their parents, compared to the people who said it was a piece of cake because their parents took the time to put together some type of estate plan, most notably a revocable living trust, discussed later in this presentation. There are 6 basic ways to plan your estate, so let's look at each one in greater detail. Plan number 1, create a will. You probably already know that in a will, you name who you want to handle your final affairs and who you want to receive your assets after you die. Your will controls assets that are titled in your name. Your will does not control assets that are titled in joint ownership or has beneficiary designations such as CDs, bonds, or life insurance. Assets in your will must go through a court-controlled process called probate. Probate is the legal process through which the court makes sure that, after you die, your will is valid, your debts are paid, and your assets are distributed according to your will. Probate is the only legal way to change the title of an asset when the person listed as the owner cannot sign his or her name. Now, of course, if you're not alive anymore, you can't sign your name, and your family and friends can't just sign for you. Only the court can change titles after someone dies. As this illustration shows, any assets that are titled in your name must go through probate so that titles can be changed. Now, of course, this process isn't free, so let's take a look at how much it costs. ARP, the American Association for Retired Persons, did a survey of probate fees a few years ago. They found, nationwide, attorney fees alone could be as much as $1.5 billion a year, and hundreds more millions go towards binding companies, appraisers, and the probate courts themselves. Probate costs vary in each state, but they're usually estimated between 8 and 11% of an estate value. In Michigan, the limit is 11% of the total estate's value. So if you own property in other states, your family could face multiple probates, each one according to the laws of that state. Probate takes time. According to ARP, the average time to complete the probate process is 15 months. It takes a minimum of 9 months, or it can go on for years. If you have ever been part of a lawsuit, you know it takes time. During the first 90 days, your estate will go through a process similar to any trial called discovery. Your estate becomes public because there has to be a notice sent out letting everyone know that if they have a claim against your estate, that you owe them money, then they need to file a form with the court. These are collected as well as the asset inventory lists, complete with net worth appraisals and statements. Your executor has to continually let the court know the progress being made on your estate, time and money, until they file that your estate has been exhausted of all its assets and debts. Probate is public. Probate is a lawsuit against your own estate, and with any lawsuit, it must become public knowledge so anyone who has a claim, legitimate or not, can file against your estate. This discovery period runs a minimum of 90 days. Aggressive marketers use this probate court notice as a great source to solicit your family for various products and services. The probate court and its solicitors, aka attorneys, not your family, has control over how your will is interpreted, how much probate will cost, and how long it will take, and what information is made public. A will is of no help if you become incapacitated, because a will only goes into effect after you die. So remember what happened to Groucho? If you can't conduct business due to mental or physical incapacity, for example, Alzheimer's disease, stroke, or heart attack, only a court appointee can sign for you, even if you have a will. Having the court involved can be expensive and time consuming. It's a public process, and it doesn't replace probate when you die. For example, when John was stricken with Alzheimer's, his son Mike needed to sell John's home to pay medical costs, but Mike couldn't sign the papers because John's name was on the title. Mike had to put his father in a court conservatorship that was expensive, time-consuming, and public. When John died several years later, Mike found himself in the courts again to probate John's will. Plan number 2 is doing nothing. If you have no estate plan, not even a will when you die, your assets will be distributed according to your state's probate laws. And if you become incapacitated before you die, the court will probably take control over your assets. Estate plan number 3 is joint ownership. This is one of the most common plans used by families. In fact, if you're married, you and your spouse probably own most of your assets jointly. The type of joint ownership most people use is called joint tenants with rights of survivorship. It means that whenever one owner dies, the surviving joint owner has full ownership of the asset. Some people think this will avoid probate and give them the control they want. Putting one of your adult children on your checking or savings account may do more harm than good for either one of you. If your child was ever sued or gets divorced, they will have to list every account that they have their name on, including yours. Let's take for example Tom and Ann. Like most married couples, they own their home as joint tenants with rights of survivorship. Let's say Tom suddenly dies in an accident. Immediately upon his death, Ann automatically becomes the sole owner of the house. There is no probate. But what happens if Ann dies? Is there a probate? Yes. That's the only way to get her name off the title and put someone else's name on it. So you see, joint ownership doesn't avoid probate, it just postpones it. Owning assets jointly can cause other problems as well. Now, let's say Ann remarries and puts the house in joint ownership with her new husband, Dan. If Ann dies first, Dan owns the house. Is Dan under any legal obligation to give anything to Tom and Ann's kids? No. The house now belongs to Dan, and he can do anything he wants with it. Even if Ann had written in her will that she wanted her share of the house to go to her children, it wouldn't have made any difference. Remember, wills don't control assets that transfer automatically to a surviving joint owner. In this example, using joint ownership caused Tom and Ann to disinherit their children. Plan number 4, giving away assets. Parents often give their assets to their children thinking it will make things easier if they become incapacitated and after they die. But what happens if you want or need that asset later? Will your children give it back to you? Maybe, maybe not. You know the old saying, never say never. Here's one time to ignore it. Never give away an asset you may need later, not even to your children. Now, another problem with giving away your assets is that you might be giving the recipient an income tax problem. An example, let's say Bob bought his home for $100,000 and today it's worth $350,000. And he gives it to his son Tom, who then sells it for $350,000. Because Bob transferred title to Tom while he was living, the house keeps Bob's old cost basis of $100,000. That's how much he paid for it. That means Tom now has $250,000 gain on the sale, and under the current tax law, he will have to pay at least $50,000 in capital gains tax. Let's look at what happens if Bob had left his house to Tom in an inheritance through a will or trust. As shown here on the right, Tom sells the house for the same $350,000, but because he received the house as an inheritance after Bob died instead of as a gift while Bob was living, the property receives a new stepped-up basis. The basis now is the value as of the date of Bob's death, or $350,000. So now when Tom sells the house, there is no gain on the sale, no capital gain tax to pay. By not giving the house to him while he was alive, Bob would have saved Tom $50,000 in capital gains tax. Estate plan number 5 is transferring assets through beneficiary designations. Many assets, including insurance policies, IRAs, retirement plans, and some bank accounts, let you name a beneficiary. So when you die, these assets will usually be paid directly to the person you have named as your beneficiaries without probate, but not always. If your beneficiary is incapacitated when you die, the court will probably take control of the funds for that person. If your beneficiary dies before you, or you both die at the same time, the asset will have to go through probate so it can be distributed with the rest of your estate. If you list my estate as beneficiary, the probate court will have to determine who my estate is. And if you list a minor child or grandchild as a beneficiary, the court will probably get involved to protect the child's interest, even if the child's parents are living. That's because insurance and financial companies will not knowingly pay large sums of money to a minor. Our last plan, plan number 6, is a revocable living trust. is being used more and more by people of all ages, marital status, and wealth, instead of a will and the other plans you've just seen. Now we're going to look at what a revocable living trust is, how it works, and how it lets you keep more control than any other plan. Let's first compare a revocable living trust and a will. Both are legal documents that have been around for hundreds of years. In both, you name someone to handle your affairs after you die. In a will, this person is called an executor. In a living trust, this person is called a trustee. And in both, you name who you want to receive your assets after you die. But, unlike a will, a living trust avoids probate when you die. You control all of your assets and prevents the courts from controlling your assets at incapacity. This process is sometimes referred to as a living probate. When you set up a living trust, you transfer your assets from your name to the name of your trust. For example, from John and Mary Smith, husband and wife, to John and Mary Smith, co-trustees of the John L. Smith Family Trust. Funding your revocable living trust is when you change the titles of your assets from your name to the name of your trust. It is important for you to know and understand that you no longer own anything. Your trust now owns it, but you are still in control of those assets. It is like creating a business which you are the CEO and all of its contents are controlled by you. By transferring titles of assets to your trust, you retain control of those assets and any future decisions for those assets, because this keeps you and your family out of the probate court system. Again, you still have full control of your assets in your trust. As trustee of your trust, you can do anything with your assets that you could do before you put them in your trust. You can buy and sell assets, change your trust, or even cancel it. That's why it's called a revocable living trust. You even file the same tax returns. Nothing changes except the names and the titles. Plus, your trust contains your written instructions for what you want to happen to your assets if you become incapacitated or when you die. In fact, you actually have more control over your assets in a living trust than without. To understand how a trust works, you need to know these four legal terms. The grantor, sometimes called the settlor, trustor, or creator, creates and controls the trust. You are the grantor of your trust, and only you, as the grantor, can make changes to your trust. That's how you keep control. The trustee manages the assets you put into your trust. Most people choose to be their own trustees. If you and your spouse are co-trustees, either of you can act and have instant control with no court interference if one of you becomes incapacitated or dies. You can also select a corporate trustee to act as your trustee or co-trustee. More about that in a minute. The successor trustee will manage your trust according to your written instructions if the trustee is unable to act. So, if you and your spouse are co-trustees and something happens to both of you, or if you are the only trustee, your hand-picked successor trustee will step in. If you become incapacitated, your successor trustee looks after your care and manages your financial affairs for as long as needed. When you die, your successor trustee pays your debts, distributes your assets. All this is done quickly and privately, according to the instructions in your trust, without court interference. Most people name an adult child, trusted friend, or corporate trustee as their successor trustee. The beneficiaries are the people and or organizations who will receive your assets after you die. A corporate trustee is a bank, financial, or trust company that specializes in managing trusts. Some people select a corporate trustee to act as a trustee or successor trustee for them, especially if they don't have the time, ability, or desire to manage their own trusts. Corporate trustees are experienced investment managers. They are government regulated, reliable, and objective. They receive special training and have a full network of resources available, including reports, analysis, and researchers to help them evaluate various markets and make decisions. As a result, they are often able to achieve better performance than an individual who usually has less experience, time, and resources. corporate trustees do charge ongoing fees for their services. One of the most powerful benefits of a trust is, unlike a will, a trust doesn't have to die with you. Assets can stay in your trust, managed by the trustee you select, until your beneficiaries reach the age you want them to inherit your assets. Does this remind you of anyone in your family? If so, you may prefer to give children or grandchildren their inheritance in installments, so they have more than one opportunity to use the money wisely. Or if you are concerned about the spending habits of one of your beneficiaries, you can provide periodic income and keep the rest in the trust. You can provide for a loved one with special needs without disturbing valuable government benefits. You can safeguard a minor child's inheritance. You can also supplement the income of a child who wants to be a teacher or do other low-paying but very important community service work. Even if you feel that beneficiary would not handle the inheritance well, you may want to keep the assets in the trust to protect them from creditors, current spouses, ex-spouses, potential lawsuits, and future death taxes. Your trustee can make distributions to the beneficiary as needed, but the assets that remain in the trust would be protected from these creditors and predators, and if invested well, could even help provide for future generations. Most people like to leave their children and grandchildren with enough so they can do anything they want, but not so much that they do nothing. With the trust, you can do this and more. No other estate plan gives you this much flexibility and control. Proven tax strategies utilizing trust have proven very effective in minimizing estate and income taxes for the grantor's estate. There are two different documents you can use when it comes to healthcare authorization. The first is called a living will. This lets your physician know the kind of life support treatment you would want in case of a terminal illness or injury. It is very limited. It only applies to life support in terminal situations, and in some states your physician is under no legal obligation to follow it, so a living will doesn't give you a lot of control. An advance directive for healthcare is much better. It lets you give legal authority to another person, like your spouse or adult child, in advance to making any healthcare decision for you, including the use of life support, if you become unable to make them yourself. This document is much broader than a living will and can be legally enforced. HIPAA authorizations are needed so your doctors will have permission to discuss your medical situation with family members, close friends, business partners, advisors, and others. If you want an estate plan that will give you all this control, both financially and medically, here's what you need to do. Follow our 5-step action plan. First, write down your objectives. Who do you want to receive your assets after you die, and when? Who do you want to manage your financial affairs? Make medical decisions. Secondly, inventory your assets and debts. Find out how much you own. Third, select a professional to help. Someone you will be comfortable with sharing this information, who can answer your questions, and who will be there when you need him or her. 4. Have the legal documents prepared. 5. Change titles to your living trust. Remember, a living trust can only control the assets you put into it. We have been reviewing trust documents for over 3 decades, and one of the most overlooked part of this process is the roles and responsibilities of the successor trustee. This can be a daunting experience because they have to juggle quite a few emotions, not to mention the time it takes away from their own careers and families in order to make sure that they get this right for their parents. There are plenty of documents and forms to file under a deadline, not to mention all the transparency and communication they have to have with all the beneficiaries. Please know that administrators are personally liable for a multitude of mistakes that could be made throughout the process of closing an estate, and it doesn't end there. Each estate has a 3-year look-back from the IRS and a 2-year statute of limitation from their heirs. There are ways to shorten this time frame down to a collective 18 months. And side note, there is bond insurance available for successor trustees just in case. That concludes the first installment of our educational workshop series on estate planning. We want to thank you for taking the time to watch our presentation and hope you receive some valuable and relevant information. The Heritage Planning Group is part of a network of other do-it-together 250 flat fee companies, and would love nothing more than the opportunity to help you in any way we can. We offer a free, no-obligation 30-minute consultation with one of our trained specialists. Whether it's one question or enough to fill a library, we look forward to hearing from you soon.